just if I forget something, but I know you're our only one attorney. So just as a reminder and for the record that we specifically requested copies of all demonstratives at the hearing and motions in limine, which was granted. The state said there were no demonstratives, and the demonstrative with the notes, which is, I would say, core to our motion for a new trial, the demonstrative that contained those notes was provided to us the morning of the day that it was introduced. Other than that, Your Honor, we rely on the motion that's been filed with the court.
Okay, thank you, and I'll hear from the state.
Judge, with regard to what defense counsel is claiming is a demonstrative, I believe he's referring to the notes that were admitted as evidence that came from the iCloud account. There was one demonstrative that was used by the state. That was the PowerPoint that depicted the faces and names and nicknames of the individuals.
That you used an opening?
That used an opening. That was not put into evidence. That was the only demonstrative that the state used. The notes were put into evidence, and that was not provided to counsel the morning of trial. That piece of evidence, and all of the state's evidence, had been made available to the defense. I had asked them to let me know when a good time was. I would walk them through my case and all of the evidence I intended to introduce. They declined to participate in that. They declined to do that. I left all of the evidence from the state in the courtroom from jury selection on through the end of the trial. They could look at it at any time they wanted to. It was available, present, and they had possession of it. So that was not something that was turned over to them the day of that particular testimony, and they were caught off guard by it. That was something that was available and made known to them for years.
I recall our conversations about that. I can't recall what date. I'd have to look at my notes, but I do have recollection that I inquired about when the exhibits were introduced, when the defense reviewed them, or the fact that they consciously did not view them, if I recall correctly, to prevent the state from saying they reviewed them, something like that.
Right, the defense mentioned...
But let me be sure what we're talking about is the same thing, apples to apples, because you're talking about demonstrative aids. Other than that PowerPoint video of the faces and names that the state used in opening, what other demonstrative aids did the state introduce, or not introduce, that did the state use in trial that you had not seen prior to trial?
Okay, so Your Honor, and I will break that up. Of course, there are the iCloud notes. That is a separate argument, and that is something that is purely prejudicial. So setting that aside and just focusing right now on demonstratives.
Right, because
again,
those were actually introduced as evidence, so that's not a demonstrative aid, the notes.
Correct.
Correct, okay, so go ahead.
Correct, Your Honor. So to break it up so there won't be any confusion in between demonstratives and notes. As for the demonstratives, we brought it up pre-trial and asked, and the government said we have no demonstratives. It's in the record. Every single demonstrative that they then brought into evidence was something that was thrown on us during trial. That included the stuff from the cell phone experts. So the government saying that this stuff was available to us, for years, that's separate. That's a separate argument than what we're talking about on the demonstratives. Ostertag's demonstrative was, and again, I apologize if I confuse it. I know that the cell phone experts, both the federal witness and also Ostertag, who's with JSO, that they both had demonstratives. One of them may have been entered in as an exhibit, but I know that one of them had a demonstrative. So Ms. Kwas is shaking her head, so I believe that that's right. So the government saying pre-trial, we don't have any demonstratives, then rolling into trial and handing us stuff that were demonstratives that was not given to us in discovery, that was not given to us as evidence, that was given to us as a demonstrative literally when they're being admitted. As for the notes, which is a separate thing and a separate argument, which is within the motion before Your Honor, those notes have no relevance. Those notes predated everything that the government was bringing up in the case. The government was allowed to introduce it in. It talks about specific acts of violence identical to this case And there is no way that the jury removed that from their mind when they were making a determination of guilt in this case. There's no way that that should have gone before the jury. And I don't think that the government can articulate how a note that was authored, and we know when notes are authored, even if they're edited, that it changes within Apple iCloud, and the date that's on it predates the death of Willie Addison, which was believed to be the reason why Charles McCormick wrote the song and the reason why there would have been motive to commit the murder here. I don't think the government can articulate how that note was at all relevant to this case and how a jury would be able to disregard that note. And again, it's all contained within my motion.
Yeah, and I understand the argument about the note. That was an exhibit in evidence, not a demonstrative. I understand you believe it should not have been admitted, and certainly the appellate court can tell me if I have made an error in that regard. What I am trying to go back and recall and review in my notes and otherwise are what you're describing as demonstratives by Agent Corley of the Federal Bureau of Investigation and the cell phone forensic examiner, Mr. Ostertag of the Jacksonville Sheriff's Office. And I'm just trying to go back to my exhibit list and my notes to recall whether those, I believe FBI agents were moved into evidence.
That is correct. There was a PowerPoint presentation that contained slides that the agent had created that depicted the cell phone tower locations as well as the location for the phones based on incoming, outgoing calls and data files, and that was moved into evidence. With regard to...
And Your Honor, I apologize for stepping in, but just in order to assist the court, just so that it's clear, is I know the state is saying those were moved into evidence. We were always, and I think we objected, that all of those things qualified as demonstrative aids and should not have been admitted. So when we say demonstrative aids, in our eyes, those were demonstrative aids and admitted over objection. So, for example, when I think I was the one that made the request at Oak Motions Eliminate that any demonstrative aid or anything of that sort be provided to us ahead of time so that we can scour through it to see if there was anything that was going to be objectionable within it. The thing in particular was the Ostertag, what I would classify as a demonstrative, but was admitted into evidence over our objection. That was provided to us the morning of. Was never provided to us before. We had a brief moment to try to scour through it before the court inquired if there was any objection. I believe we laid our objection that it shouldn't be admitted at all, as it is merely a demonstrative aid. And that, I believe, was also the piece of evidence, the compilation that contained the notes. We then discovered, we were only able to discover the date timestamp of the note after the court had admitted it into evidence when we asked the state to provide us with Mr. Robinson's physical phone, which we never had access to before. But we then looked into it and was able to determine the date and time. That was brought to the attention after it was already admitted. I just want to make sure like that the timeline is clear and as to what we are classifying as the demonstrative aid, but yes, Mr. Cooper is correct. Ultimately, it was admitted into evidence, but over the defense's objection.
Yes, and I do recall that, and that's why I wanted to be clear. You all might be calling it a demonstrative aid. I'm calling it an exhibit in evidence because it was indeed moved into evidence. So the argument that it was improperly moved into evidence is recognized, and certainly that can be an issue for appeal, and it could be an issue in your motion for new trial. But what I'm hearing is these exhibits in evidence, what I'm calling exhibits in evidence and you're calling demonstrative aids, you're saying were never previously provided to you prior to trial.
Correct, Judge. The compilations. I know that Mr. Cooper is saying, well, all of the raw data, I would just classify it as raw data, like all of the individual pieces of evidence were provided to us, and the court is aware of how many thousands of pieces of evidence and pages and social media and all of that was included in this case. So yes, it was, but what we had specifically requested at the motions in limine, because of the voluminous nature of the discovery in this case, that anything that they intended to introduce as a compilation to provide it to us timely so that we would have an opportunity to go through and lay proper exceptions. So I just wanted to that is somewhat of an Ortennis addendum. Just I wanted to add that also to everything that was written into the motion for new trial by Mr. DeCoste.
All right.
So
Okay, thank you.
Sorry, Judge.
No, nothing. Anything further on your motion?
No, Judge, I think everything else, we're relying on all of the argument, unless Mr. DeCoste wants to jump in, everything that he had put in the written motion.
Okay, anything else from the state?
Judge, just regard to the last part, again, regardless of what we're calling it, these pieces of evidence that I offered at that hearing to show them every single thing that I had and intended to introduce that would go before the jury. They deliberately decided not to look at that, and I believe during trial articulated to the court that that is their common practice, because they don't like to look at something and say that they have reviewed it, and then later something that maybe they did not see was introduced. And that's their practice, and that's fine. But I've listed everything in discovery. I've did an exhibit list that outlined everything. I left it in the courtroom, and I offered weeks before this to walk them through every single piece of evidence that I intended to introduce. They had copies of it. They were aware of it. I don't know what else I could have done.
Okay.
Your Honor, I can reply to that, please.
Okay.
It's-
Last thing, because we've gone back and forth, which is
Well, it's our
what I
motion that-
normally do, but go ahead.
Just for the record, it's our motion. We made the initial argument. They responded. I would want to reply, if the court will allow.
Well, I was allowing him to respond to the Ortennis addendum, which was not included in the motion. So if you want to reply to that only, then you may. I think I've heard enough already about the other issues.
Understood, Your Honor. The standard practice that I explained on the record is this, that the government under 3.220 has an obligation to list and provide all items of discovery. As a matter of practice, when a prosecutor says, hey, come and take a look at our file, I decline to do that because it opens up an opportunity for a prosecutor to say, well, it was in my file. You would have seen it, but you didn't look at it. So this was not a situation of us being dilatory or us trying to be willfully ignorant. We said, anything that you have, provide it to us so that there is a receipt, so that there's a record that we know that we have it. As for these demonstrative evidence, it would have been as easy as Mr. Cooper loading it into an email and sending it to us. The government chose to wait for these, what were initially introduced as demonstrative exhibits, to wait to provide those to us. That is not the right way to do it, and it's not right to say that somehow we didn't because we chose to not physically go to their office and look through their file for the reasons that I had explained. As for the notes, I still don't think the government has articulated how a note from 18 months prior, when they moved to introduce it to the court without telling the court that the note was so old. Remember, they had the phone, so if we're talking about looking at evidence, they could have looked at their own evidence, the phone that was in their possession, and said, hey, we're trying to move into evidence a note that is years before any of this incident, but they didn't look at that. It was only because we shared that with the court. I think for that reason alone, that it would mandate a new trial. As for the demonstratives, I've made my argument. Thank you for allowing me to reply.
All right, thank you so much. All right, well, of course, the 4 issues raised in the motion were all addressed during the course of the trial. Objections were raised by counsel. The court heard the argument from the parties and ruled on them. So that none of this is new that I hadn't heard before. But having considered the motion in its totality, and of course, having sat through the trial, at this time, I'm going to deny the motion for new trial. All right, that said, I know we were originally scheduled for sentencing this week. At the request of counsel, we are postponing that. I know the PSI for both Mr. Whitaker and Mr. Robinson have been prepared, and I think were distributed to counsel last month at some point on the 24th or 25th of August, something around there. So let's go ahead and pick a date and time certain on which you can come back for a sentencing in this matter, because normally we do sentencing some 30 days after trial. We're now at the 6-week mark, having picked this week for everyone's convenience. So let's try to find a time, if we can, this month to return for sentencing. So as you know, here in our jurisdiction, we have every week is a trial week, so I don't know what trials I have going or not going, so, and I don't know how long they are to last, but if I'm to do a date time certain to accommodate, and I do this for other cases that I have out-of-town counsel who need to travel, Friday is the best day I can do, because we pick juries every Monday, and then we try a case, and if it's a 2 or 3 or 4 day trial, that has less opportunity to impact on a Friday. So if you have Fridays available, I have every Friday this month available, and Fridays into the beginning of October, then we get a little dicey.
Your Honor, if it's Fridays, and I can explain the reason why, the only date, and I don't know if Ms. Quas is available, will be the 19th. On the 25th, I have a sentencing before Judge Williams. It's a plea sentencing. And that is at 3 o'clock in the afternoon. That would be a really tight window to get to, Your Honor.
19th works for me. Does it work for the state?
Judge, I'll make it work.
And we don't know about Whitaker, but we'll inquire of Ms. Schlax to see if she can come on that day. But even if she can't, there's nothing to say we can't have separate sentencings, even though that would make victim's family have to come twice. They're entitled to be heard. So if that works, we don't need to really talk about other dates. But what time, I don't know if y'all are driving or if you're flying. I have all available from 9 a.m. to 5 p.m.
So I would ask for the morning because I have a special set deposition on the afternoon of the 19th, but it's by Zoom. So even if I'm still in Jacksonville, I can make accommodations to conduct that deposition. So if we can do the morning, that would be the request that I would make.
I can do the morning. Do you want right at 9 a.m.?
I'm open, so whatever everyone else, yeah.
Are you trying to catch an early flight Friday morning? Are you coming Thursday? I mean, I can do it at 10, I can do it at 11, whatever accommodates.
If we could do 10 on Friday, Your Honor, that would work.
Okay.
That's
Mr.
fine.
Trooper, that works for the state?
Yes, Judge.
Okay, then we'll do September 19, 10 a.m. for sentencing, and how long do we think that will take?
Judge,
How many folks are you going to present?
Judge, I think I may have 2 statements, 15 minutes
Okay.
most.
And from the defense?
I think we could complete it within a half hour.
Okay. All right, then we'll schedule it for 10 a.m. on Friday, September 19th. The other case will just travel along to pretrial conference on that date. And anything else we need to take up from the state?
No, ma'am.
Anything else we need to take up from the defense?
No, Your Honor.
Okay, then we are in recess in this matter. Thank you.
Thank you, Your Honor.
Sorry. I'm sorry? Oh, that's right. We're not in recess. Never mind. Sorry. We need Mr. Williams back. Okay. All right, we're back on the record in the matter of Mr. Dirk Williams, case 23 CF 207. Yes, sir, Mr. Williams?
Hey,